Video games? Degrees? Is this college for criminals? Sun's primetime lineup goes behind the bars to show you what really goes on in Canada's prisons. Tuesday night, all primetime, all the shows. Don't miss it.
And we'll be talking all about Canada's prison system right here on Byline tomorrow night. So right now, though, I promised you this on Friday, we would talk about this terrorism case that was brought back into the news by a leak to the French-language Montreal newspaper La Presse. Adil Sharkawi and Abousfian Abdelrazik, two men long at odds with the Canadian government, a leak saying that they are on an intercepted phone call plotting a bomb attack on a plane. How did that information get to La Presse? What does it mean? Are Canadian courts capable of handling intelligence, or is this an attempt to smear two people? Now, Michelle Junot-Katsuya is with the Northgate Group and formerly worked in the intelligence world. Well, you still do, just not for the government now.
Exactly.
Now you're on the corporate side.
Exactly.
So this leak is from what they say, according to La Presse. We haven't seen the documents, but La Presse says this is an intercept of a phone call in 2000 between Abdelrazik and Sharkawi, planning some kind of attack in a Montreal to Paris type flight.
The document itself that La Presse is basing its story on is actually a memo that was sent from CSIS to Transport Canada and the Privy Council. Within that document, there was a series, a chronology of events that took place on several years. And in those events, one of them was this conversation that took place between those two individuals. Very, very preoccupying sort of series of events. Not something that Mr. and Mrs. Everybody will sort of do or leave sort of a trace of misinterpretation. Very serious events that led the CSIS to investigate much further their activities, their link, their contacts, and ultimately their intentions.
Now, all of the information that La Presse has reported on from this leak memo, the lawyers of the two men have said, no, it's not true, and this is an attempt to smear because we're in the middle of lawsuits and there's criminal proceeding or court proceedings going on. So the leak, though, appears to have some things in it that CSIS wouldn't present before the courts.
Well, the true perspective is that the information was presented, the evidence was presented in court, and CSIS failed at that time to get the evidence admitted to court during the court procedures. So it's not necessarily if everything was rejected because it was wrong. They failed to get it admitted. So that's slightly...
So what is that? Explain the difference.
Well, that means basically that the judge did not accept the evidence that was presented to them, but it doesn't mean that it's because the evidence was necessarily wrong. It was simply that for the court purposes, for the procedures at that time, the court rejected the evidence. Very likely because CSIS didn't present it properly. Now, the lawyers failed to do their job.
Is it that they didn't present it properly, or that intelligence, which is what CSIS, our National Spy Service, does, collects material in a different way than police officers do?
Absolutely.
Okay, because I know you were quoted in our papers on the weekend as saying our courts just aren't able to handle terrorism cases and cases involving intelligence. And intelligence services operate differently. They're out there trying to gather facts. They're not necessarily looking for a conviction.
Exactly. Totally different than a police department like the RCMP, for example, who will sort of bring the evidence with the ultimate goal to get a conviction in court, in criminal court. CSIS, as an intelligence service, its sole mandate is to gather information, analyze the threat, analyze the risk, and then present recommendation to the government, which allowed the government also to take certain administrative measures that are not necessarily ruled by the court or presented by the court. So, like, for example, deciding that somebody should be on a no-flight zone, a no-flight list or something like this. These are administrative measures that the government can take in light of the information presented from CSIS. So the bar is not exactly the same thing. Another thing also is that when CSIS was created in 1984, it was out of the bad doing of the RCMP during the 70s, and it was very, very adamant for the people who created CSIS that they shall prevent CSIS officers as much as possible to go and testify in court. So they're not geared to collect evidence for court. And we saw the fiasco that we had with Air India, which demonstrated very, very much that they were not ready to do so. And again, and again, and again, we see it's now being repeated. They need to sort of refine, review their way of doing things, and eventually maybe prepare themselves to testify like it is done in many other Western countries.
I want to ask you about the way certain things have been handled. We're running out of time, so I won't be able to ask you about Sharkawi and the security certificate because he's not a citizen. But Abdelrazik was presented with cash by the Canadian Labour Congress. And I was in the room when they did this. Now, he is on the UN, what is essentially a UN no-fly list. It's a list. They suspect him of having terrorist ties, so it puts all kinds of restrictions on him. The Canadian Labour Congress gave him cash and dared the government to come and bust them for it, because that's against Canadian law. They received an official complaint from Scott Armstrong, a Conservative MP. My understanding is that the RCMP has never responded to Mr. Armstrong and never investigated. Would they be hesitant to investigate because that would allow Abdelrazik to challenge all of this in court and maybe have some of this thrown out?
Very difficult here to sort of come with a clear verdict of exactly what took place and what led to the decision of not going after this particular situation.
But it would seem that, I mean, saying here, we're giving you money, it's against the law, come arrest us, which is what essentially they said. It's a summary from the stage. You'd think they might try and arrest somebody or at least investigate.
It kind of echoed to a certain extent the demonstration we had a few years ago on the Parliament Hill, where the Tamil supporters of the LTTE went around with the LTTE flags and sort of took as a and stormed the Parliament Hill. Nobody was arrested. And it is clearly, under the Anti-Terrorist Act, illegal to go and sort of support openly terrorist group of that nature. And the LTTE at that time was officially a terrorist group on the Canada list. So in that perspective, we're seeing again this situation where you've got probably agencies that are walking on a fine line, and they're trying to not sort of take the bite of finding themselves stuck in a situation like basically it became with Mr. Sharkawi and the other people under the security certificate. The security certificate was from the get-go a bad procedures, was from the get-go a way to sort of get into trouble. And CSIS got in deep trouble to the point where they had to pull out in those cases rather than to go forward and to proceed. Not necessarily because their evidence was wrong, we don't know, we didn't see it officially, but more because they couldn't go forward with the sort of some of the fundamental that they want to do, which is not to testify, not to show their evidence, and certainly not to show the evidence the way it was collected. And maybe some of the collection process might just be too much borderline to be accepted by the court system. And that's the reason why we need to return now to the table and to sort of change the law.
Reforming CSIS, we'll have to leave that for another day. Michelle Juno Katsuya, thanks for coming in. Make sure you stick around. We're not done yet. Bird